I'm there.
Ma'am, am I audible, ma'am?
Yes, sir. Yes, sir. You're audible.
May I start
Yeah,
today's
yeah.
session?
Yes, sir. Please, sir.
Okay, ma'am. Okay, ma'am. Thank you, ma'am. So, good afternoon, everyone. It gives me a great pleasure to welcome you all to the seventh lecture of Mission Nyayadrishti Samvad, an ambitious marathon series of 100 online lectures initiated by the Department of Law, School of Legal Studies, Central University of Karnataka. This mission was formally inaugurated on 24 September by our esteemed Vice Chancellor, Professor Battu Satyanarayan Sir, and Honorable Justice H.P. Shandesh Sir of the High Court of Karnataka. The initiative is envisioned as a step toward expanding access to legal education in alignment with Viksit Bharat 2047 and the Sustainable Development Goals also, by inviting eminent scholars from India and abroad to share their expertise voluntarily. The mission ensures accessible, inclusive, and equitable education for learners across the country. It is scheduled every Friday for the next 2 or 3 years. It seeks to bridge the legal gap between academicians and learners, fostering dialogues, critical thinking, and global exposure. Today, we are truly privileged to begin this journey with Lecture 7, and I am delighted to introduce our distinguished resource person, Dr. Preethi Harish Ma'am, Assistant Professor, Vaikuntha Valiga College of Law, Udupi. Ma'am holds her BLLB degree from Vaikuntha Valiga College of Law, Udupi, and a master's degree in law with a specialization in international law from the Postgraduate Department of Studies in Law, University of Mysore. After that, she obtained her PhD in law from Karnataka University, Dharwad in 2024. Her doctoral research, revocation of special status and its impact on the enforcement of fundamental rights in the state of Jammu and Kashmir, a critical study. She began her illustrious academic journey in 2006 as an assistant professor of law, and since then she has made remarkable contributions to both academic and co-curriculum growth in her institution. She has been also an active resource person in numerous seminars, workshops, and academic programs. In April 2022, she was chairing a paper presentation session in the National Seminar on Intellectual Property Rights at Vaikuntha Valiga College of Law. She also played a key role as a judge in several Advocate Shivaji Shetty national level moot court competitions and has presented research papers at various national and international seminars. In addition to her academic achievements, Ma'am has also contributed to the publication The Changing Scenario of Intellectual Property Rights and the Way Forward, which is published in December 2023 by Vaikuntha Baliga College of Law, Udupi. We are deeply honored, ma'am, to have such a distinguished scholar among us today. On behalf of everyone present, I extend a warm welcome to Dr. Preethi Harish ma'am and look forward to an enlightening and engaging session ahead. Thank you so much, ma'am. The session is now over to you. Thank you, ma'am.
Thank you for such a wonderful introduction. Thank you so much. So, before I commence my talk, I think I would like to really thank Central University of Karnataka Department of Law for providing me an opportunity to put forward my thoughts on the topic which I'm going to discuss now. At the same time, my thanks or uh, uh, my thanks goes to Dr. Jain sir and his team for coordinating this event because it has been very meticulously coordinated. So thank you so much for giving us this platform to share our thoughts and views. And it is a 100 series session, which is very much it's a good initiative. So taken by the department, I would like to congratulate and thank you once again for providing us this opportunity. So shall I start with my presentation? Sir,
Yes, ma'am.
yes, okay, sir. Thank you, thank you.
Yes, ma'am, you are audible.
Yeah, okay, sir. So, first of all, a warm welcome to all the participants who have joined this session. I've taken this topic on surrogacy and reproductive rights, reassessing the legal framework and its implication. Being a woman, I thought this topic would be of much relevance to all the married couples as well as to all the women, because a reproductive right becomes a very essential right connected with right to life and personal liberty, especially for a woman as such. So, going on with the introductory part, so we all know that parenthood is what is considered as a great boon to the couples, and most of the parents they would like to have the child biological through biological means, but there may be some problem with some of the couples, not only in India, but if you look into globally, there are a lot of problem with the couples, the problem of fertility issues through which they cannot have the child of their own. So at that time, the question arises whether a reproductive right is considered to be one of the human right that is given to an individual. So I would like to say that earlier probably reproductive right was not considered that that very essential. But now when we look into the changing scenario or the changing dimensions of Article 21 that is connected with right to life and personal liberty, probably this reproductive rights is considered to be the fourth generation right, but it has its root in the first and second generation right, which is called as civil and political right and economic, social, and cultural right. But because of the scientific development and because of the modern technology, it has been placed under the fourth generation right as such. So, reproductive right is very much essential and it is considered to be a part of right to life as such. Then, what is this reproductive rights? So, if you look into the definition that has been given by the International Conference on Population and Development, which was held in the year 1994, they have given a very precise definition regarding the concept called as a reproductive rights. So, reproductive rights, which allows every couple to decide the number of pregnancy, that means how many children they want to have, the time of pregnancy, and when to be pregnant or when to be a parent. So that without any kind of compulsion, without any kind of coercion, or without any kind of discrimination. So basically, it allows a couple or an intended couple, we can say, or a married couple as such, to have the choice to have the child. But the same definition was been upheld or it was been accepted by the World Health Organization, and they also have recognized the definition given by the international conference, and they have elaborately told that reproductive rights are not individual right, but it can be considered as a bundle of right given to a couple as such. So this is not connected with one individual. It is a choice or it is a decision taken by both the individual as such regarding having of children or in the method of having of child. All these things are connected with the reproductive rights. So when we come to the problem that has been faced, see, I told you many a time the couple they want to have children biologically because everybody want to have the children that way. But there may be a lot of fertility issues connected with women or connected with a male or a female. Lot of fertility issues will be there. So when this kind of fertility issues occur, what is the next option or what is the solution for this? So if you look into this assisted reproductive technology, we have an act connected to that. So this assisted reproductive technology gives a solution to the couple who cannot have children biologically. So so what is this assisted reproductive technology then? So it is a what do you say? It is a kind of a procedure or it is a set of procedure what we can say which talks about having the child through artificial way. That means it allows a woman to what do you say extract the egg from egg as well as a sperm from the male to fuse it in a medical laboratory or in a fertility clinic and to put this embryo into the uterus of the woman so that she can conceive the child. So these scientific development have been taking place just to see that the parents have been provided with a golden or with a beautiful opportunity of having a children. Or else there are other methods also. Adoptive method is also there whereby they can adopt it. But over here they would like to have their own child through their own gametes whereby the egg and the sperm can be fused and they can have a child on their own. So this assisted reproductive technology gives them the option so that they can have a child of their own. So when we talk about this assisted reproductive technology, it even talks about what do you say, giving solution regarding fertility issues also. So there are different methods of this assisted reproductive technology. We all know it is called as IVF. First method is called as in vitro fertilization. whereby the same thing happens, whereby the procedure is very tedious over there. Many a time the people through first IVF procedure may not conceive a child. They may not. But later on, they may have to undergo one, two, or three. The procedures have to be done two or three times, and it is very, what do you say, tedious, very time-taking procedures. But that is also a method, one method which comes under the assisted reproductive technology. This which is called as an IVF. And another method, what we really want to talk is about surrogacy. So, surrogacy is also kind of an assisted reproductive technology method whereby the surrogate, the mother, she carries the child for the intended couple. That means she becomes a carrier, or she becomes a, what do you say, a vehicle whereby she conceives a child through an artificial method, and she delivers a child and gives a child back to the intended parents. So surrogacy is also kind of an assisted reproductive technology. If you would like to talk about this assisted reproductive technology, I would like to say that in India, the second baby, which was been born in Kolkata through an assisted reproductive technology, and the first baby was born in UK in the year 1978 through the assisted reproductive technology method. In India, in the year 1978 itself, the baby was being born, and she was called as Kanupriya, and she was being named as Durga. And Dr. Subhash Mukherjee did this procedure whereby the baby was been born through IVF method. So we have tried using this IVF method, and India, I would like to say, it is the second country to have the child through IVF method, and the child was been born in Kolkata as such. Now, when we come to the concept called as in surrogacy, we all know that surrogacy is an arrangement whereby the I would like to call a surrogate mother. The surrogate mother, we have two parties over here. One is a surrogate mother, and second is the intended parents who want to have the child. So, surrogacy is a procedure whereby the lady carries the child to the intended couple. So, if you look into the definition of surrogacy, I've taken a few definitions over here. So, if you look into the definition of a surrogacy, the word surrogacy originated from the Latin term that is called as a subrogate, which means to substitute or to act on behalf of another. So, if you look into the general term, surrogacy is nothing but it is a pregnancy whereby a lady carries the child of an individual or a couple. I would like to define the word individual because the concept of individual has been highlighted in the Surrogacy Regulation Act. So, when we look into the definition of surrogacy, here a woman is carrying the pregnancy for an individual or for a couple, and she hands over the child after the birth to the intended couples or to an individual. But if you look into the Surrogacy Regulation Act 2021 under Section 2, which clearly defines that, again the same definition has been given, whereby the woman carries or she gives birth to a child, and later on she delivers a child to the intended couples, whereby the child has been handed over to the intended couples as such. So this is the definition given under the Surrogacy Regulation Act. But if you look into the definition given by Black's Law Dictionary, they have given an elaborate definition regarding the concept called as a surrogacy. The reason is that why I'm telling you elaborate definition has been given. The reason is that here they have made a procedure, they have defined even the procedure, how the surrogacy can be done. Because here they have defined the what is a procedure of the traditional surrogacy as well as gestational surrogacy. So in these two methods, the surrogacy can be done and the child can be delivered to the intended couples. So the Black's Dictionary defines a surrogacy as what do you say? The surrogacy can be in a genetic by a what is a genetic mother, that is by traditional surrogacy, or can carry an embryo created by an artificial method that is called as through a gestational surrogacy as such. So now we have looked into the definition of a surrogacy. So if you look into the definition of a surrogacy, it's very simple, whereby the surrogate mother carries a child in a womb and she delivers a child to the intended couple. So as per the Surrogacy Act as such, after the delivery of the child, there is no connection between the mother and the surrogate mother and the child as such. It is more like a contract. So thereby she doesn't have any kind of connection with the child as such. The surrogate mother does not have any connection with the child. If you look into the kinds of surrogacy. As I told you, under Black's Law Dictionary, they have given a clear-cut, what is a definition regarding the surrogacy as such. But if you look into the kinds of surrogacy, surrogacy can be of different kinds of surrogacy. First is the method how it has been followed. We call it as a traditional surrogacy, which is called as a first method, or it is called as a direct method of surrogacy, whereby the what do you say? It's a method whereby the eggs of the surrogate mother are being fertilized with the commissioned father. That means here the surrogate mother contributes for the birth of the child. So that is called as a traditional surrogacy. She becomes a biological mother. So there are two kinds of traditional surrogacy that can be done. One is through the medical, what do you say, in the fertility clinic, the surrogate's mother egg will be taken and it will be fused with the father's sperm and again put back to the, what do you say, ovaries, so that what do you say, she can have a child. That is one method. Second is through intercourse also. But under this traditional surrogacy, the surrogate mother becomes a biological mother to the child because she contributes her egg for the, what do you say, development of the fetus as such. But when we come to the gestational surrogacy, the surrogacy simply carries a child in her womb and she is not genetically connected with the child. So, either biologically or genetically, she does not have any connection with the child. She is mere a carrier. So, basically, she takes a child in the womb, more like a, what do you say, a contract or more like a business. And she delivers a child to the couple. Once the work is over, the child is delivered to the couple and the work is done. So she does not have any kind of connection with the child as such. But when we come to again other two methods, because nowadays, like we have seen in 2020s, not only that in 2015s, India had become a, what do you say, hub for surrogacy. Lot of people had come to India only for the surrogacy purpose. So at that time, the surrogacy was again divided into two parts or two kinds of surrogacy that we can say. One is called as a commercial surrogacy and second is called as a altruistic surrogacy. So commercial surrogacy, we can say it is more like a business whereby the surrogate mother is being paid. So here she's been paid not only for delivering the child but also for the carrying the child and for other expenses also, for example health expenditure and other treatments. So everything she's been paid, and once the delivery has been done, the particular sum has been paid to her and she has been done with the surrogacy. So that becomes a commercial surrogacy and it was a matter of issue. I will let you know why it became a matter of issue. So we had a concept called as a commercial surrogacy also, whereby it became a business. There was no connection between the mother, surrogate mother, and the child. She was merely carrying the child and delivering the child. But at the same time, when we look into the altruistic surrogacy, I would like to say it is a gesture of kindness, whereby the mother carries the child, the surrogate carries the child in a womb, but she does not have any kind of compensation that has been given. Maybe the medical expenses or the health expenditure will be taken care of because delivering the child takes 9 months as such. So during that time, the medical health expenditure or any other expenditure will be taken care. Apart from that, no compensation will be paid to her. So I would like to say that this surrogacy becomes an act of kindness whereby she tries to, what is say, help the intended couple to deliver the child because they have some medical conditions. Because of medical reasons, they cannot bear a child. So that is the reason she is helping them out to give birth to a child and hand over the child to the intended couples. So these are the four kinds of surrogacies what we can look into: traditional, gestational surrogacy, commercial surrogacy, and artistic surrogacy as such. So moving on with the next thing, as you all know that now when we look into Surrogacy Regulation Act of 2021, which is in force now, so why this act has come into existence? There is a reason behind it. Because in order to have an act, there must be some mischief. And in order to reduce that mischief, an act has to come into existence. So keeping this in mind, there was a commercial surrogacy that was been prevailed. So if you look into 2002, or if you look into early parts of 2000, lot of foreigners used to come to India, and it became more like what do you say, baby producing country as such. So the women's were been exploited, the girls were been exploited, especially the girl who attained the puberty. She was been taken into custody, maybe by your family members or by the brokers. They were misusing it, and she was kept in the fertility clinic. I would like to mention over here is that lot of fertility clinics were there in Gujarat, in Kolkata, in Andhra Pradesh, many of the places. So the girls who have been exploited. Further in 2002, India became a sole, what do you say, nation, okay, to have this surrogacy procedure. The reason is that, first of all, the expenditure was very less in India as we compare to UK. Because in India, probably the surrogacy procedure was being done within 5 lakhs. Later, it went up to 10 lakh as such. It was being done. And people could easily travel to India. The reason is that the medical process bill was very, what do you say, it was very cheap, and traveling was very cheap, staying also was very cheap, and surrogacy became very cheap as such. So surrogacy as such, commercial surrogacy, I'm saying, it became, what do you say, a business in India. Though we had the Transplantation of Human Organs Act of 1994, which says that the human organs cannot be transplanted just like that. So embryo becomes a human organ over here. So though we had this act, still the surrogacy was being continued or it was being followed in India. And no steps or no measures were being taken against this. The reason is that, see, how the surrogacy, what do you say, practices happened in India. See, basically, they were bound by the Indian Contract Act at that time, but now we have a Surrogacy Regulation Act. But I'm talking about 2000 when the business, what do you say, fast grew in India. So they were governed by the Indian Contract Act of 1872, whereby there was an agreement between the surrogate. There was a broker for her, surrogate, and the intended couples. So the agreement is that because there was an offer, the offer was being done by the intended couples, and many a time the foreigners used to come to India and avail this facility. Offer was there, acceptance was there, consideration was there. So keeping that in mind, there was a private contract between the surrogate mother, intended couples, and the broker. So basically, it became, or it was being regulated by the private contract as such. So this surrogacy became, what do you say, fast moving, and commercial surrogacy became a business of the day. So coming back, when this kind of a situation occurred, whereby the girls were being exploited, they were not being paid, though they became the surrogate mothers, they were not being paid enough, and the brokers took half the money, and the girl had to be a surrogate mother multiple times because they were not concerned about her health, and her health is connected to her life. So her right to life was being exploited not only by her family members, even by the brokers, and economically, for economic purpose, she needed, what do you say, fast earning. She needed a survival. So that is the reason even she used to accept this kind of an arrangement whereby she became the surrogate mother multiple times. So when she was being exploited, and even the child, sometimes the child was having some kind of a ailment. Okay, sometimes they were twins children were being born because embryo were been injected, like the what do you say, embryos were been injected, and two children were been born. So the couple, the intended couple, they came from abroad, or the Indians, they wanted to have only one child. But when two children were being born, the other child was being just abandoned. And many a time when there was a medical issue, the children were being abandoned. And children being born in India, they got the Indian citizenship because the surrogate was Indian. So that is the reason when all this problem occurred, there were people came forward and they demanded that a regulation has to be done. So whereby this kind of a practice has to be regulated and it has to be controlled through the law. So even the law commission as such, it came forward and they said that yes, something should be done to regulate it. See, NGOs came forward, infertility clinic came forward, various human rights activists came forward, and they said that this practice has to be regulated. The rights of the surrogate mother has to be protected. The child also has to be protected, and this practice is more like a mischief which have to be regulated. And I told you, most what do you say, women available to become a surrogate were in what do you say, Anand, that is Gujarat, Kolkata, Pune, Mumbai, Madhya Pradesh. So there was, what do you say, a fertility clinic which were not been registered. Some were registered. We were giving a normal procedure as such, but many of the fertility clinic were also not been registered as such. So they thought that yes, something should be done. So, at this time, the Assisted Reproductive Technology Bill and the Surrogacy Regulation Bill was been introduced to protect the rights of the individual as such, so that this practice have to be regulated. So that is the reason how this act came into existence, because the commercial surrogacy was going on to such a scale that some kind of regulation had to be drafted to control this kind of a commercial surrogacy. So now coming back to the history and evolution of Surrogacy Act. See how the Surrogacy Act of 2021 came into force, and what is the history behind, or what is the journey behind this act. See, in 2012, the Confederation of Indian Industry report, it gave a report that around 3,000 to 4,000 fertility clinics were registered. That means fertility clinics were there in India. Some of them were registered and most of them were not registered. Not only that, India became a, what is say, 2 billion. It made income of 2 billion. And most of the time, this money was been given, taken by the third party. The people who were involved with this practice of surrogacy were being deprived. So there was a need to have this, what do you say, act as such. So I told you unregistered what fertility clinic which were not been registered, they started booming up. They started coming up, and they started giving advertisements saying that we try to do surrogacy and we have a procedure of surrogacy. So whereby lot of exploitation was being done. There was human trafficking also, whereby the eggs or the, what do you say, the girls were being used to donate their eggs. Donors, they became the donors, and it was being treated. So girls were being exploited, children were being abandoned, and there was a need to stop this kind of a mischief. So mischief rule was being applied over here so that some kind of a benefit can be given. So the Law Commission came forward in its 208 report, which was presented in the year 2019. So whereby they recommended that, according to the Law Commission report, they recommended that the commercial surrogacy had to be regulated or it has to be banned. So here, when we look into the kinds of surrogacy, we have altruistic surrogacy also, which I've already referred. So they wanted to, or their intention was to ban this commercial surrogacy as such. So there was an effort by the members of the parliament to produce the bill or to place the bill before the parliament. So the first effort was done in the year 2016, whereby the bill was been presented before the Lok Sabha. But because there was a dissolution of the parliament at that time, in the year 2019, as such, the bill could not be moved before the parliament as such. So, in the second effort, in the year 2019, again the Surrogacy Regulation Bill 2019 was introduced in the Lok Sabha, and this time the bill got the assent. So, on February 2020, the Union Cabinet approved the Act and received the assent of the President on 25th December 2021. So finally, a bill came into existence which banned the concept of commercial surrogacy. So this act came into force on February 25th, 2022. So we call it as a Surrogacy Regulation Act of 2021 as such. Now, I would like to talk about some of the cases whereby which has added up to the implementation of this bill as such, or to bring into force of this bill. So, first case that happened, that is called as a Baby Manji Yamada case as such. So the case happened in 2008, and that happened in Gujarat as such. This case. So in this case, the Japanese couple actually they had come for the surrogacy. In brief, I would like to talk about the facts. So they came to India for a surrogacy, but because of some kind of a problem between the couple, the wife had to go back and the husband went because his visa had to expire, and the baby was being left over here with a surrogate mother. So now the question occurs, who has to take care of the child, because there was no law in India to regulate commercial surrogacy as such. Whether the child should be given to the parents, whether they have to come back and take the child, or whether the child becomes a part of the surrogate mother who is not ready to keep the child as such. So that was a big question which was being faced. And not only that, when you talk about the concept called as a citizenship also, even that matters over here. So finally, the court came to a conclusion. Court stepped in, Supreme Court stepped in, and they gave what do you say, a permission, and the child was been handed over to the grandmother so that she can take the child back home. So it was been given to the grandmother as such. So the question over here is that what is the, what do you say, where do we stand if this kind of commercial surrogacy has been allowed? What happens to the future of the child? Whether the child become an Indian citizen, whether it should be taken care by the surrogate mother, and whether the child, what happens to the child if the surrogate mother does not want it, whether it needs to be abandoned. All this question occurred. At the same time, we had Jan Bilza case versus Anand Municipality, which occurred in the year 2010. Here also, it was a German couple actually, but they had come to India, but the Germany did not accept. It was a twin. The twin children were been born, so the Germany did not accept it, and they said that we cannot give the citizenship as such. Finally, the Supreme Court stepped in again, and there was a negotiation, and whereby the children were been sent back to Germany by the parents. But again, the concept occurred whether the child becomes an Indian citizen because the surrogate becomes an Indian. So these are the two important cases that really had to redefine whether the surrogacy should be allowed, if allowed, which kind of surrogacy should be allowed, and whether we need a law to regulate such kind of procedure. So when we come to Suchitra Srivastava case, which is not connected to surrogacy, but it is connected with the abortion. Here again, when we talk about Article 21, that is called as the reproductive rights. So court said that the woman have got the right to decide regarding the reproductive right, whether she wants to have the child, whether she wants to abort under medical terms, she can abort the child. Actually, this case is regarding a mentally retarded girl who was been sexually abused. But when the case was being decided, the court held that when we talk about this, the court also came to a conclusion regarding the surrogacy as such. So surrogacy becomes what do you say? It has been guaranteed under the personal liberty. So it has been accepted by the court. Again, when we come to Justice K.S. Puttaswamy case, which all we all know regarding right to privacy, again Article 21, though it is not connected with surrogacy, but still we have some connection. We can connect it with Article 21, whether or not to have a surrogate or whether to have a reproductive rights. That is connected with Article 21. That becomes connected with Article 21, right to life and personal liberty of an individual. So that has to be taken care when we looked into the judgment of K.S. Puttaswamy case as such. So these are the cases I would like to, I mean, it has been referred, which also has a, what do you say, stepping stone for the drafting of Surrogacy Regulation Act 2021. Now, going back to the features which are given under the Surrogacy Regulation Act, I would like to talk about some of the very important features that have been given. First of all, I told you regarding surrogacy, two parties are there over here. One is called as an intended couple, and second is called as a surrogates. Third is regarding fertility clinic also because they become a part of it. So when we come to the conditions that have been placed for a surrogate couple as such, the conditions laid down by the Act for the surrogate couple. First of all, the surrogate couple should have a medical condition. Medical condition in the sense, the Act clearly says that the medical condition means over here the Act clearly tells that the couple should have some fertility issue. Maybe a woman is not in a position to carry a child. Okay, a lot of IVF what procedures have been done, but the her uterus is not in a position to carry it. She must have some kind of a medical illness, life-threatening disease, either severe diabetes or some kind of heart disease, whereby she is not able to carry the child, or there were multiple miscarriages, unexplained medical miscarriages might have happened to her. That is a reason why she is not able to have the child, and maybe the uterus has not been found, or the uterus is not being found. A lot of medical issues may be there. So in case the couple is having a medical issues, only then they will have got, or they have the right to avail the procedure under surrogacy, or they can take the benefit of having a child under the surrogacy. Second condition is that for the intended couple, certificate of recommendation from the district medical board. See, basically, the district medical board has been established by the appropriate authority. The appropriate authority may be the state government or the central government as such. For the union territory, it becomes a central government. So they have to authorize, the district medical board also has to authorize that they are infertile. That means they have a medical condition because of which they can avail the benefits of surrogacy as such. So they must have a certificate of essentiality. So that means they cannot have a child. So that is the reason why the law is helping them to have a child. So this certificate of recommendation is very much required. And the next thing is that the intended couple must be married. So now, as per the act clearly says that the intended couple must be married for a minimum period of 5 years as such. So this 5 years has been done mandatorily. So there were a lot of cases whereby a person was married for 4 years also were not being given this benefit. They say that the act clearly says that they must be married for a minimum period of 5 years as such. At the same time, the Surrogacy Regulation Act also helps the overseas citizens, the non-residential Indians, to avail this facility, provided they should have a card. Overseas card should be there in the name of intended couples, both male and female. And one condition is that the person availing the surrogacy shall be an Indian citizen. That means they have banned the foreigners. And in 2015, the foreign nations or the foreign people have been banned to come to India to have the surrogacy. So they were not been allowed at all. The reason is that they come here, do the surrogacy, go back. Many a time the child is not been accepted in their home country. So all this problem occurred. They may abandon the child. So in order to avoid all this complication, this act gives the privilege only for the Indian citizens to have the children. Next, the act clearly talks about the age limit as such. See, age limit has been kept in mind because of the biological changes that take place with the human as such. So the age limit for a woman will be from 23 to 50 years. So woman who's of 23 to 50 years can avail this facility. Then the male should be within 25 to 55 years as such. So basically, 26 to 55 years, that is the age limit for the male. So the female will be from 23 to 50, male people from 26 to 55 years. That is the age limit. Apart from that, they have been barred from taking the surrogacy procedure. They cannot take the surrogacy procedure if they have exceeded the age limit as such. The next condition that is given to an intended parent is that they should have one surviving child. That means they should have a child of their, sorry, they should not have a child of their own. So in case they have a child of their own, that means they can have the child biologically. So they are capable of having the child biologically. So they are not permitted. So the intended couple should not have any surviving child. But there is a condition over here. Supposing the intended couple, the couple, married couple, they have a child who is physically and mentally incapable, or he's having some kind of a life threatening disease. They have a child, but the child is having a life threatening disease which is not curable. So in such cases, those couple can avail the benefit of surrogacy. Or else, if they are already having a biological child, such couples are not being allowed to have surrogacy arrangement as such. But if the child is medically or physically incapable, or the child is having some kind of a life threatening disease whereby it cannot be cured, or the child may not survive, because we come to know the survival rates are very less. In such cases, the intended couple can go for surrogacy. And the act also permits a single woman to offer surrogacy. In the definition part, I spoke about the individual or the intended couple. So here the concept of individual comes over here. So this act is allowing a single woman to offer surrogacy. She is called as an intended woman. But still here the condition is there. The condition clearly states that the intended woman shall be a widow or a divorcee. That means she must be a widow or she must be a divorcee. Only then she can avail the facility, and her age shall be within 35 to 45 years. After 45 years, she can't have it because of biological reasons also. And one thing I would like to say regarding this kind of a surrogacy whereby intended woman want to have a surrogacy, she tries to donate her eggs and she takes a sperm from the donor. So whereby through the surrogacy it has been allowed as such. So here a divorcee or a widow can opt for surrogacy provided she has some medical problem and that privilege has been given to her. Now, the next concept comes is who can be a surrogate as such. See, the Act lays down the eligible condition for a woman, keeping in mind the health as well as the psychological, the changes that happen to her, to find out who is called as a surrogate mother or who can be a surrogate mother. So, a surrogate mother can be any willing woman should be married who should be married as such. So in 2024, there was a amendment that is done to the surrogacy regulation rule 2022, whereby they have used the word a willing woman also. They have specifically made a mention about it. So this willing woman shall be a close relative. So, a willing woman who is willing to take up this procedure of surrogacy and a close relative can be a surrogate mother. And the next condition is that she should have a child of her own. That means she must be capable of bearing a child, because many a time there is a miscarriage, there may be abortions, and so many other things happen. So at that time, if she is able to carry a child of her own, that means she is medically fit to take up the surrogacy as such. Again, the age limit for a surrogate mother is also been fixed, that is between 25 to 35 years of age, keeping into consideration her health issues also. That means her right to life has to be protected and she cannot be merely exploited. So within 25, that means the maturity comes over there. She is able to decide for herself whether she can have this procedure, or as an act of kindness, whether she can help the people out through the surrogacy. So this age limit has been kept as 25 to 35 years. And she cannot provide her own gametes to become a surrogate. That means she cannot provide her own eggs to become a surrogate. If she provides her eggs to become a surrogate, then she becomes a biological mother. And when she becomes a biological mother, she will have some kind of a connection with the child. Maybe the because she sometimes she may be the close relative. The surrogate mother can be a close relative. So when she sees a child in near future, she will have some kind of an intimacy towards a child, and that may lead to a lot of complication. So the act has clearly made a mention, but I would like to say that some changes have been done to the act. But as per the provision of the act, they say that she cannot provide her own egg or gametes to become a surrogate mother, and she cannot be a surrogate mother more than once. So, in case you allow a lady or a woman to be a surrogate for more than once, then she can be easily exploited. So, that is the reason why only once she's been allowed to be a surrogate mother. And here again, the certificate of fitness shall be given by the district medical board. So they have to certify. So she must be gone for a medical screening, saying that she is physically as well as psychologically fit, because during the pregnancy time a lot of psychological changes happen, variations happen. So she must be certified, saying that she is physically fit by the registered medical practitioner, that saying that she can take up this surrogacy method or surrogacy procedure. So these are the requirement to be a surrogate mother as such the act has given. So, where can it be conducted and the procedure? See, many a time the surrogacy has been done in the fertility clinic, because the registered fertility clinic, the surrogacy has to be done, and the surrogacy fertility clinic shall be registered, and they must renew their registration after every 3 years, because 3 years is a requirement that has been given. So they have to register it, so that the law also comes to know that they have been registering. And many a time, if the surrogacy has been conducted by this infertility clinic, they have to keep the records for nearly 20 to 25 years. The record has to be maintained. In case a record has been needed for near future, so 20 to 25 years, the record needs to be maintained by the registered medical clinic as such. So now, when we talk about the procedure regarding this surrogacy as such, what is a procedure? See, when we talk about the procedure to conduct the surrogacy, first thing is that consultation and assessment. That is called as a medical assessment as such. So here, both the couple, intended couple, and the surrogate, they have to undergo both physical as well as medical, psychological, as well as medical screening has to be done. And they must, what do you say, by the registered medical clinic as such, to say that they are eligible for this, because they have to meet all the condition. See, the intended couple should be infertile, they must not be able to carry the child. So that will be certified only by doing the medical examination. So over here, the first procedure is that consultation. They will be given consultation, they will be spoken, they will be told about all the procedures, and after that the medical assessment has to be done to find out whether they are infertile, and whether this medical concept of surrogacy can be allowed, or whether it can be what conducted on the surrogate mother. So they must get a certificate. First thing is that. Second thing is that legal formality. So when I talk about the legal formality, there are two things over here. One is regarding obtaining of certificate. See, when we talk about surrogacy, which happened prior, no certificate was needed. The girl was taken, she was tested. If she was capable to bear the child, then automatically in the laboratory, the egg and the sperm was being fused and it was put into her uterus so that she can deliver the child and give. But now it is not like that. Now the act clearly talks about the legal formality. So legal formality, I would like to talk about two things. One is regarding obtaining of certificate. Second is regarding documentation, that is called as drafting of legal document. So when we talk about obtaining of certificate, the first certificate there, what they are supposed to obtain is from the district medical board or from the state surrogacy board. They are supposed to obtain the certificate of essentiality. Certificate of essentiality is that claiming that it is very essential to have the child through surrogacy. That means that intended couples are not in a position to bear the child biologically. So it is very much needed or essential for them to have the child to continue with the concept of parenthood. So certificate of essentiality is very much needed. Second thing is that certificate of eligibility. See, confirming that both are eligibility. So basically confirming that both are eligible and they meet all this criteria. The age limit is there. She has to be surrogate only once. So all these criteria are there for a surrogate to be eligible, and even for the intended couple, they must not have any child. In case they have a child also, the child must be having some kind of a medical physical problem as such. So all these are called as eligibility requirement, and the district medical board has to give a certificate of eligibility. So certificate of essentiality very much needed to have in surrogate. Certificate of eligibility confirming that they meet all the requirement that is given under the act. The third certificate what they're supposed to take is that is called as a parental order. So basically this certificate is given by the magistrate, whereby they say that once a child has been born, the surrogate has to hand over the child to the intending parent. So over here the court passes a parental order, whereby once a surrogacy has been done, the child has to be handed over to the couple, and the couple have to take the child in whatever condition. In case the what you say the child is physically not capable, or the child is having some kind of issues, the parents have to take the child as such. So they cannot abandon, they cannot leave the child, they cannot hand it over back to the surrogate mother. So over here they're supposed to take a certificate from the magistrate, that is called as a parental order. So certificate of essentiality, certificate of eligibility, and parental order. Next thing is that next legal formalities regarding the insurance document. See, earlier under the old act, insurance concept was not there, but now they're supposed to mandatorily make a insurance for the surrogate mother for 36 months. That is, we can say for almost 3 years after the delivery, the insurance will be there. If she has any kind of medical emergency because of surrogacy, or a health deteriorates, or any kind of side effects happen, at that time it can be covered by the insurance. So 36 month of insurance has to be given. That is one concept of legal formality. Second thing is that an agreement has to be drafted, that is a legal document has to be drafted. So basically this legal document has to be drafted between the intended couple and the surrogate, talking about their rights, their duties, and how the child has to be delivered. So basically, this legal document has to be drafted between the parties, so that if the contract has not been done, or basically it is a legal binding document as such, so they have to fulfill this document. So these legal formalities have to be fulfilled. Next comes the IVF cycle, that is called as an embryo creation. So basically, embryos have been created, and maybe at times sometimes as per the act, that is a surrogacy act, the couple have to what do you say donate, or they should be part of this embryo creation. That means they have to donate their egg and the sperm. But in case you're not able to donate because of medical issues, then a donor's egg or donor's sperm can be taken. So here, through the IVF cycle, the embryo has been created, and next the embryo has been transplanted to the surrogate, and then the pregnancy has been monitored and she's been supported. So basically monitoring has to happen, because many a time there may be miscarriage or there may be an abortion, all this what do you say, cases can happen. So she has to be monitored, and the final stage comes, that is called as a delivery and legal handover. That means through the parental order, the child will be legally handed over to the intended couple. So there the surrogate does not have any connection with the child as such. So next, if we look into the act, that is the Surrogacy Regulation Act. This Surrogacy Regulation Act of 2021 has spoken about the right of a surrogate mother and the child. So when we talk about the right of the surrogate mother, so what is the right of the surrogate mother? So surrogate mother has to be informed. That is called as right to be informed. What information shall be given to her? So she must be informed about the procedure. She must be informed about the, what do you say, effects, the side effects of this entire process, and she should be informed in the language that is best known to her. And she must be the signature must be taken after giving the proper information, saying that she has given a consent to be a surrogate mother as such. At the same time, she has a right to withdraw the consent before the embryo has been, what do you say, placed in her uterus as such. So basically, before she becomes a surrogate, she can withdraw the consent, and even the withdrawal of the consent shall be in writing, and she may specifically give a reason why she wants to withdraw the consent as such. And regarding the abortion also, if the abortion had to be done under medical termination of pregnancy act, under that condition, if the abortion has been allowed, she must be told why the abortion has been allowed, and the consent has to be taken. So here the fertility clinic or the doctor or the district medical board does not have any authority to abort. But in case the child is life threatening or she has a lot of complication, then in such cases the child can be aborted, but with the consent the child has to be aborted, and again the signatures have to be taken. But when again there is one more right, that she should know that she should have an insurance coverage of 36 months. So that is very much mandatory for her to know about it. Now when we come to the rights of the child, see, sex selection of the child has not been permitted. So basically, selection of the sex of the child has been prohibited. So that cannot be done. And the next thing is that child should be considered as a biological child of the family. So whatever rights a biological child gets, the same right shall be given to this surrogate child also, who become the member of the family. At the same time, the child shall not be abandoned, the child shall not be exploited, the child shall not be used for human trafficking. So many a time even human trafficking was been done through the surrogacy. When the child was been done, the child was taken as a for the what do you say, trafficking, begging purpose and all those things. But the act clearly says that the child shall not be used for any illegal purpose, and it becomes a member of the family. So coming to the next one, people who are not allowed to have this arrangement, surrogacy. So couple who are having children cannot avail it. Foreign nations cannot avail it. People who are in live-in relationships cannot have this surrogacy. Single men and single women cannot avail the facility because they have not been married. So that is the reason they cannot avail it. Gay or lesbian couple also cannot have this surrogacy, and widower cannot have this surrogacy as such. So they cannot have the facility of this surrogacy as such. So one more thing I would like to talk about is this. See, at the initial stage, I told you that a surrogate mother cannot donate her egg. But, and that is a rule given under the Surrogacy Regulation Act. But the Surrogacy Regulation Rule of 2022 in March 2023 has, what do you say, has made an amendment. Now the donor gametes can be used. That means the surrogate can donate, or the eggs can be donated. And because in case the intended couple is not in a position to contribute for the development of the child or to have an embryo, in such cases the donor gametes can be used for this kind of a fertilization. And in October 2023, the Supreme Court has clearly told in Arun Mutawil case versus Union of India, whereby such kind of procedure can be allowed. In this case, a woman was not in a position to donate her eggs. So at that time, the donor's eggs were being taken, and it was being fertilized, and the surrogacy procedure was being carried forward. But again, why this amendment has been taking place? This amendment has been taking place for the benefit of the provision. provision because when the district medical board certifies that if the intended couple are serving are couple are suffering from some kind of a medical condition, they fulfill all the criteria which are given under the Surrogacy Regulation Act, but they're not able to contribute the egg or the sperm, then in such cases the donor's egg or the sperm can be taken, and this amendment has been done in order to give some benefit to the intended couple as such. Now, there was one more case which was been recorded, that is called as Vijay Kumari S. and others versus Union of India, that was recorded in the year 2025 as such. See here, the problem, the question that was been raised before the court was that, say this act came into existence in the year 2021. So this act does not have a retrospective effect. But in case the intended couple who have already started the procedure before 2021, whether they can continue with the procedure of the surrogacy or whether they have been barred. So here the Supreme Court has clearly told that if the procedure has been started, fertilization, everything has been started before the act has come into existence, then there is no bar regarding those intended couple. They can carry forward the procedure and they can have the child through the surrogacy arrangement as such, because the act will have only prospective effect and it will not have a retrospective effect. So coming back to the last part, that is called as a critical analysis. See, when we looked into this Surrogacy Regulation Act, probably it is a good step taken by the by the government by having this act as such. But at the same time, there are a lot of people who have critically analyzed this act as such. The reason is that, see, many of people don't get married now. They want to be single. They don't believe in the concept of marriage. So at that time, whether they should be allowed to have the surrogate, because we have seen a lot of celebrities like Karan Johar and all, they have donated their sperm and they have become the surrogate fathers. So it was been allowed. But when a person does not want to get married, maybe a male or female, but they want to have a child of their own, whether this act, why this act is stopping them from having this procedure? Because critically, if you analyze this act, LGBTQ community, single fathers and unmarried person, they cannot avail this right. So whereby they say that there is a violation of Article 14 and Article 21. So Article 14, equality before law and equal protection of law comes over here. Likes have to be treated alike. So basically, when all these people have the same condition, and when you talk about a divorcee or a widower, she's been allowed to have a surrogacy treatment, but these people are been barred. So it is violating the Article 14. At the same time, right to life, because right to get married or not is their personal choice. But if they don't want to get married, but they want to have a child of their own, then this act is prohibiting them to have a child of their own. So that was been what is say critically analyzed. And one more thing, in Navjit Singh versus Union of India, the Supreme Court has decriminalized Section 377 regarding same-sex marriage. They said that it has been decriminalized. But in case of the same-sex marriage couple, they cannot pursue this or they cannot have the surrogacy. They have been barred from taking the facility under the Surrogacy Regulation Act as such. So again, there is a violation of Article 14 and Article 21 as such. The next critical analysis is that, see, basically when they clearly say that the lady should be a close relative willing couple as such, it becomes very difficult, because nowadays nobody will come forward to be a surrogate mother. Nobody will tend to. Only because of act of kindness, somebody should come forward. But apart from that, nobody will come forward to be a surrogate mother. But when it was commercialized earlier, they used to get lot of women who were ready to be a surrogate mother, because they were getting the child, at the same time the surrogate mother was getting a lot of income. But because of this ailment, that is she should be an intending couple, should be a close relative. That is one reason whereby a lot of intending couples are being deprived of being a surrogate, having a child to surrogacy, though we have an act. So they fulfill all the criteria as the intended couple, but they're not able to get the surrogate mother. That is one provision which has been critically criticized. And ban on commercial surrogacy. If they say there is a ban on commercial surrogacy, it has to be properly regulated. There may be a lot of clinic who are undergoing this procedure, but it has not been notified to the government or to the authority as such. So it will give a a window open to the people to follow this procedure of commercial surrogacy, but without knowing it to the government. So this kind of offences may still continue. And the provision that is given under the Surrogacy Regulation Act to have a surrogacy is very tedious. It's a very prolonged procedure. because they have to be medically fit, they have to give the certificate, they have to get the order from the magistrate, only then they have to procure or go with the surrogacy procedure. So the procedure becomes very tedious, and many a time the intended couple, they do not want to avail this facility as such. So coming back to the conclusion, what is the conclusion that is regarding this act, and regarding to the critical analysis and all those things? I think that, somewhere, if we have to ban this commercial surrogacy as such, so somewhere, it has to be not being regulated more strictly. The thing is that only altruistic surrogacy has been allowed. So the surrogate has been compensated only for 36 months, and after that, she's not been taken into consideration. So ban on commercial surrogacy, I feel it has to be reconsidered again. Maybe some kind of criteria should be kept, whereby a willing woman who is ready to be a surrogate, maybe a lot of conditions which are given in the act can be applied to her. And one more thing, when we talk about the concept of equality, equality has to be ensured for all individuals, because most of them are being barred from taking this facility or being a what do you say, being a parents, they have been barred. So equality has not been taken into consideration, it has to be rethinked of. And one more thing, the procedure that has been given under the Surrogacy Regulation Act, it has to be more simplified, because certificate of necessity, certificate of essentiality, everything has to be fulfilled. So probably the procedure may be taken care of. And one more thing, the requirement of a close relative who must be a willing woman as such. So even that can be taken care of. Who is a close relative has not been defined. So age limit is there, but who becomes a close relative is not been defined. So probably even that can be taken care of. And over here, the main aim of this legal framework. So it is it's a provision of compassion, fairness, and respect. And this arrangement has been done so that people can avail the provision of surrogacy, or just to carry forward the concept of parenthood, so that they can enjoy the parenthood as such. So probably the act should think about the concept of fairness, respect, and compassion, keeping everything in mind. Probably it can be rethought of while going with the necessary amendment as such. And when we talk about the offense, suddenly an fertility clinic, which has not been registered, but they are going against the concept of the Surrogacy Regulation Act, then such offences are non-bailable, it is non-compoundable also. At the same time, the penalty will be imposed as 10 lakhs, and 10 years of imprisonment will be given to the concerned person. So that is the penalty which will be imposed. And coming back to the last part of my presentation, frequently asked question: how many times can a woman act as a surrogate mother? Because act clearly tells that it is only once that she can act as a surrogate mother. How many attempts of surrogacy procedure can be undertaken on a surrogate mother? Normally, it is only once what they can do, a surrogacy procedure, but under special circumstances, three embryos can be, what you say, injected to her, or it has been, what you say, procedures can be used. But for the, as per the law, it is only one time the procedure can be done. But if under special circumstances, three times the procedures can be done. Can a surrogate mother withdraw her consent from surrogacy? As I've already told, yes, she can withdraw, but before the embryo has been implanted in her, she has to, what you say, withdraw her consent to be a surrogate. And what are the penalties? I've told you. Penalties are 10 lakhs, 10 years of imprisonment, and everybody will be held liable because they have violated the norms or the rules of the Surrogacy Regulation Act. So they will be, what you say, penalized for 10 years, and 10 lakhs will be imposed on them. Whether Gayman's donation is allowed in surrogacy. As I told you, as per 2025, when the amendment was being done, so Gayman's gestational surrogacy that we call. So a surrogate can donate, and what do you say, she can be a part of it only when the intended couples have some kind of a fertility issue. Then in such cases, the donor's eggs or the sperm can be used. Or else it is the, what do you say, intended couple, they only have to contribute for the surrogacy procedures. So they have to be part of it. So they have to be certified by the medical board saying that they are not able to be a part of the surrogacy procedure. That means they cannot contribute. So infertility is there. That is the reason only then they have been allowed. So I think with this, I would like to wind up my presentation. Uh, so regarding the Surrogacy Regulation Act,
Thank you very much, ma'am, for your valuable insights and for taking the time to share your expertise with us today. It was a truly an enlightening session for us, ma'am. And as we already see that, ma'am, in your slide, you have already mentioned frequently asked question, and you have already question your answers. But in case of our rules, so the floor
Yes.
is now open for discussions. If anyone has any questions or concerns or discussions regarding our today's session, please unmute yourself one by one or write your concern in the chat box. Please, if anyone having doubts or queries or discussions, please go ahead.
Good morning, ma'am. Good evening, ma'am.
Good evening. Good evening.
Very good presentation, ma'am. So,
Thank
as
you.
you said, when a woman has a certain medical issue, she cannot become a mother naturally. So,
Yeah.
but how does she become eligible to be a surrogate mother, ma'am? In case frequent miscarriage, so how does a mother with such medical issues become eligible, ma'am?
Madam, over here, I told about the medical condition for an intended couple, ma'am. So, in case husband and wife, they have to be husband and wife, this provision has been given to them. So, husband and wife, if they have a medical condition, surrogate should be medically fit, ma'am. So, that is the reason what I've told you to be a surrogate. To be a surrogate mother, she should have a child. So, when she's having a child, it is presumed that she is capable of carrying a child in a womb. But regarding the intended couple, husband and wife, if the wife is infertile, that means she is not in a position to carry the child. Many a time, the uterus or the embryos have been created outside the uterus, ma'am. It is not possible. One more
Yes,
thing. And second thing is that the lady, the wife, she's having a heart disease. It is not capable for her to carry the child. Or acute, what do you say, she's a diabetic. Or take for example, she has tried lot of IVF. Okay, in vitro fertilization has been done, and the embryo has been implanted in a womb, but lot of miscarriages has been done. So at that time, she's not possible. It is not possible for her. You can't drain her. You can't torture her more. So when she's infertile, only then she can offer surrogacy. But surrogate's mother has to be fit enough, ma'am. Because surrogacy can happen only once in a lifetime. So she should be fit enough. To be a surrogate mother, she should have one child. She should have a child. Only then she is capable to be a surrogate mother.
okay, ma'am. Thank you, ma'am.
Okay, okay, ma'am. Yeah.
Any other?
Yes, sir.
So, ma'am,
Yeah.
I think everything is cleared. I
Okay.
guess.
Yeah.
So, ma'am, just I am. We are concluding our session today.
Yeah.
So, thank you, ma'am, for delivering such an enlightening and thought-provoking lecture on surrogacy and reproductive rights, reassessing the legal framework.
Thank you, ma'am.
Yeah. Thank you.
Your talk has shed light of intricate relationship between law, ethics, and also reproductive autonomy, which helping us to understand the evolving legal landscape surrounding the surrogacy in India and beyond. Ma'am, we are deeply grateful for the time and effort you dedicated to preparing and delivering such an engaging and comprehensive lecture. We also extend our heartfelt thanks to our respected Vice Chancellor, faculty members, participants, and everyone present here for their support and active participation. With this, we conclude today's session. Thank you, ma'am, once again, and we eagerly look forward to your continued engagement in the upcoming lecture of this series. Thank you so much, ma'am.
Yes, sir. Thank you. Thank you so much for providing me an opportunity. And I thank all the participants also for their patient listening. And thanks to the department. Again, thanks to Dr. Thanks to the department as such for providing us an opportunity. Thank you so much. Yes, sir.
Thank you so much,
Yeah,
ma'am.
yes, sir. Thank you.